Oh, I'm here to address it. She can't see it. I'm sorry.
On the record, in the matter of the people of the state of Michigan versus Vincent Flores, file number 22-01987, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Thank you. Good morning, Your Honor. Robert Palmer of the Public Defender's Office, appearing on behalf of Mr. Vincent Flores, who's here via Polycom from the Ingham County Jail.
Okay, Mr. Flores, today was the date and the time that was reset for sentencing. You were supposed to be present before this court for sentencing. And it looks like you failed to appear. Also looks like I don't have a pre-sentence report because of that.
That's correct, Your Honor. The only materials I've received as a result of that are a write-up from a no-show report from the probation. He did fill out the packet for whatever that's worth, but I guess the actual report was never generated.
Okay, so he was arraigned on the bench warrant on August 31st and remanded per my bench warrant. And then I see a note here to refer to probation. I don't know if he got a new referral. Did he get a new referral?
Your Honor, not to my knowledge, and when I met with court staff yesterday to see if there was a PSI available, what I was provided is the old, I think the only thing that was in the file is what I have, which is the old no-show report dated 12/1/22.
Is he being held on my bond only? Or
That's correct, Judge. In this case that he's set to be sentenced on, he's got a no bond hold. In the other felony matter that is scheduled for preliminary exam next week, he has a $5,000 cash bond. I would anticipate that he's unable to post that bond.
Okay, so I will get a new referral for him to meet with probation. And if he's not undergone a substance abuse assessment, he'll be ordered to do that. And then I'll reinstate the bond of $4,010%.
First at 8:30.
December 1st at 8:30 is the new sentencing date.
December 1st at 8:30, you said?
That's correct.
Understood. Thank you, Judge.
Mr. Flores, do you have any questions for the court today?
No, ma'am.
Any additional matters for the record, counsel?
No.
You're all set. Thank you. On the record, in the matter of the people of the state of Michigan versus Clifford Frost, file number 23-02212, FY, council appearances for the record.
Good morning, LaDonna Logan on behalf of the people, P69715.
And good morning, Your Honor. Kevin Kievsky, P74-153, appearing on behalf of Mr. Frost, who's immediately to my right. And I also have co-counsel here with me today. If he can actually give his appearance quickly.
Yes, Edward Kickham, P70332 for the defendant.
Okay, today was the date, and you all can gather at the table there.
Thanks.
Today was the date and the time that was set for the motion hearing. I have a motion for summary disposition and then a motion to sever.
That's correct. And there was also a motion to dismiss due to prosecutorial misconduct, which was properly noticed and served. However, at this time, we're going to be respectfully withdrawing that motion. We may bring that back later on. Given the people's response, we believe there might be additional exculpatory information that we would be entitled to pursuant to Brady v. Maryland. And we're just going to be working with the Attorney General's office to see if we can get that additional information. So at this time, it's really just those two motions that you've mentioned, Your Honor.
Okay, so you're withdrawing the motion to dismiss for prosecutorial misconduct?
That's correct.
Okay, and so we'll first take your motion for summary disposition. You can make your argument.
Thank you very much, Your Honor. Well, first, as a preliminary matter, I know that this is somewhat unorthodox that an individual would seek a summary disposition in a criminal case utilizing MCR 2.116 C8, but we believe that the law and the facts make that permissible in this case. The reason being because, first, the civil procedure rules do apply in criminal cases, as is articulated in MCR 6.001D. When it comes to the people, they have said in their response that this is something that is exclusively within the purview of the civil rules of procedure and only civil cases. However, we maintain that is not the case. As you have seen in our filings in our brief, People v. Grove, also People v. Schultz, shows how particular matters of civil rules of procedure are applicable in criminal cases. And furthermore, if I take a look at 2.116, it doesn't say that that particular rule regarding summary disposition is only used in civil contexts. And there's really no analogy or anything similar for summary disposition contained in the Michigan Rules of Criminal Procedure or Chapter 6. I know that the people also state that when it comes to a preliminary examination, that is the only route or the only way in order to tackle a case, but we would say that that is not true. Dispositive motions are permitted pursuant to court rules. And in fact, we did cite a few different cases within our brief, one in particular where an indictment was dismissed by a district court. So with that being said, it just as a preliminary matter, we do believe that this is something that can be raised. If I may get to the merits, Your Honor, taking a look at the timeline here, we have a few different statutes, and I'm not going to read my whole brief because I know that the Honorable Court read everything already. But first, Mr. Frost, in addition to the other 15 that were charged, they are essentially electors that were picked by the Republican Party. This is pursuant to MCL 168.42 or period 42. And then when it came to election day, people were able to vote for presidential electors, and that's pursuant to MCL 168.45. And then after the election was essentially canvassed by the Board of Canvassers, and they reported to the governor who won, and that was at that time and still is and forever will remain President Biden. The governor, pursuant to 168.46, filed a certificate of ascertainment stating that when it comes to the election, that election was won by Biden, and more so when it comes to the 16 electors, who those Democratic electors would be. And that was essentially given to the Congress in addition to other appropriate individuals. We have that particular item contained as Exhibit C within our motion. But really, when we take a look at all of this here, we see one big important thing. There was absolutely no forgery in this case. None. Why? Because when it comes to forgery, forgery requires that you actually have an act that makes an instrument appear what it is not. And second, you need to actually have a risk, a real risk to expose someone to loss. In this particular case, you don't have either. For example, if I take a look at the instrument that the individuals allegedly or purported to give to Congress and to other individuals, they didn't claim to be the Democratic electors. They signed their own names. This is a political protest, if anything. They did not state that, they had the governor's signature or the secretary of state's signature or the Great Seal of the state of Michigan, all these other things required by the various statutes and the various laws that we cite in our brief. They just sent in a certificate, which is contained, as you have seen within the brief, as an exhibit. And there's also no potential exposure to any type of loss. I'd like to point the court's attention that this is a requirement in Re Lloyd, a Michigan Supreme Court case contained at 424 Mich 514. It's a 1986 case. And why was there no loss? Because the governor, she wrote a certificate of ascertainment. She said to the folks in Washington, D.C., these are going to be the Democratic electors. These are going to be the individuals that will be voting. You'll be hearing from them later on December 14th. And then on December 14th, of course, we had a whole bunch of different things being submitted to Washington. The Democratic electors submitted their certificate. And when it comes to the Republican electors, they allegedly submitted their certificate. Even when it comes to that particular certificate, it's not a forgery. And there was no way that anyone could lose. Why? Because Congress is required by statute. And specifically, if we take a look at 3 USC 5 and 3 USC 6, and also 3 USC 15, all of these particular federal statutes state that it's going to be based upon the conclusiveness of what the governor has put forward, and that is that certificate of ascertainment. So no one could have been exposed to any type of loss. No one in this particular case can say that there was a dummied up certificate where it forged the governor's signature, the secretary of state's signature, it had any type of seals, anything like this. It is legally impossible, absolutely impossible for these folks to have committed a crime with the facts being alleged. So pursuant to MCR 2.116C8, taking a look at the allegations and in the most favorable light toward the non-movement, and that is the people here, there is no crime still. There's absolutely no crime. It precludes even the necessity for having a preliminary examination because that brings up questions of law and fact. And a dispositive motion would be the appropriate venue, and that's why we're bringing this here to ask for this case to be dismissed.
Thank you.
Oh, one more thing, if I may. And that is, when it comes to the people's response, I think it's very important to note that they did not submit anything whatsoever, not one shred of argument, evidence, law, statute, anything to fight against or to contradict what we have put forward. They just said blindly that this is not something that you could do, a motion for summary disposition. That's it. They didn't even argue in the alternative. They had 20 pages they could have done all this, and they just decided not to write anything. The way that I take a look at this, and many others I would contend, is that this is really an admission that all the different things that we have stated in our motion are true. And if true, we should be prevailing here, and Mr. Frost should be set free.
Thank you. Ms. Logan, you can respond.
Thank you, Your Honor. First and foremost, the people believe that the criminal matter before this court is properly governed by Michigan Court Rule 6.110. As it relates to Michigan Court Rule 2.116, in order for there to even be a motion of summary disposition, there has to be either a civil action where there are agreed upon stipulation of facts, or there has to be some sort of stipulation of facts sufficient enough for the court to render a judgment in the action. Point in fact, there are no facts on this record as to this case. An attorney's arguments are not facts. Filings are not facts. The proper way to elicit facts in this case is the preliminary exam, which is governed by the Michigan Court Rule 6.110, as the people stated in their response. This is a complaint, and the court's jurisdiction is set forth in 6.110. And as far as making a determination on how this case is to proceed, whether it does proceed to trial or whether the court finds that the evidence is insufficient as to probable cause is all governed by 6.110, and it requires a preliminary exam. The people, just like the defendant, have a right to a preliminary exam, and the people have not waived their right in this case. And we believe the defendant's motion for summary disposition should be denied.
Brief response or rebuttal, if I may. Briefly, when it comes to this particular case, this is not a question of fact. Again, it's a question of law. And when we take a look at what has been put forward by the people on its face, and this is what a C8 motion is about, it is not sufficient to actually sustain the charges or what the people are looking for. There is no relief that could be granted, given that it's a legal impossibility for these folks to have possibly committed any type of crime being alleged here regarding forgery.
Thank you. You can have a seat, sir.
Thank you.
Thank you. Okay, I've reviewed the briefs and the responses to those briefs, and also reviewed the attached legal basis for the defense argument. The concern that I have, I agree or tend to agree with the Office of the Attorney General as it relates to when it's appropriate to apply Michigan court rules. I don't think we're in a situation here where it is appropriate to bring a motion for summary disposition. This is a criminal proceeding. It's a felony criminal proceeding. And a felony, the defense and the prosecution has a right to a preliminary examination. And the purpose of the preliminary examination is to require the prosecution to put forth sufficient evidence, that's facts, to establish if they have sufficient probable cause that a crime was committed and probable cause to charge your client with the crime. We've not done that. So to make an argument that we should do a disposition based on a summary of the proceedings would be inappropriate, and it would be preemptive. It should be something that should be, if given or taken before the court, maybe at the circuit court level, definitely not at this level, because we've not even had a preliminary examination. We don't even know if they have sufficient facts to determine whether or not a crime was committed. All we have is a pleading, and the allegation here is that there's several counts of a crime being committed. Count 1 being conspiracy to commit forgery. Count 2, forgery. Count 3, forgery. Count 4, conspiracy to commit uttering and publishing. Count 5, uttering and publishing. Count 6, conspiracy to commit forgery, election law. And then count 7 and 8, forgery, election law. We first need to have a hearing in the court, and that would be an evidentiary based hearing for the Attorney General's office to put forth evidence and to determine, and the court will make that determination as to whether or not there's sufficient evidence to determine whether or not there was a crime that was actually committed, and if so, there's sufficient probable cause to charge Mr. Frost with that crime. And as you should be aware, that's a low burden. It's not a heavy burden to overcome. It's more than mere suspicion that a crime was committed. So for those reasons, your motion for summary disposition will be denied.
Thank you,
This
Your Honor.
matter will be proceeding to a preliminary examination. We also have the matter of a motion to sever.
Yes, Your Honor.
And I don't need you to obviously re-argue your entire motion. I do want you to, however, address the response that was provided from the Attorney General's office, where they indicate, and I would agree, that you failed to articulate any reason why there would be a requirement for a severance in this matter.
Well, if I may, Your Honor, taking a look at the court rules, specifically MCR 6.110A, it speaks about co-defendants. In this particular matter, Mr. Frost, in addition to the other 15 defendants, are just simply that. They're defendants. They're not co-defendants. They were not all charged in the same charging instrument. It appears that when it comes to the preliminary examinations that have been set up, that is for 10-12, in addition for 11-2, that is something that the various other attorneys, or more so the other defendants, have agreed to do so en masse. I would argue that when we take a look at this particular case, because Mr. Frost is not technically a co-defendant, he's not able to be joined with others in the same preliminary examination. I would say that we could certainly take a look at a court rule, and that court rule is MCR 6.121. That talks about permissive joinder, about separately charged parties, and those parties could be joined together. But that's only if we actually have a criminal information, and we're not at that point because we haven't had a bind over at this point. And furthermore, even if this court would say that they are co-defendants, which I would maintain factually that they are not, that they would certainly have antagonistic defenses and offer proof, as the prosecutor has brought up, or the assistant attorney general has brought up. That's not required per the court rule for 6.110A for any type of joinder or severance for preliminary examinations. In fact, that's something that's required by court rule if we're at the circuit court level. So what I'm asking here, Your Honor, is that we have a separate and distinct preliminary examination for my client, because there is not proper authority, nor was there any type of joinder here. If the Attorney General wanted everyone to be together and mandate that, that would have to be done in the same charging instrument, but they were all charged separately. And it's kind of perplexing as to why they were all charged separately. I'm not sure what the strategy or what the rationale was. Doesn't matter to me. But what does matter to me is that my client certainly has a right to a preliminary examination that be separate and distinct, and he cannot be joined with other, I'm going to call them de facto co-defendants, because there isn't a single charging instrument.
Ms. Logan, you can respond.
Thank you, Your Honor. Just to supplement my response, Michigan Court Rule 6.110A says that the preliminary examination of co-defendants shall be consolidated, and only one joint preliminary examination shall be held unless the prosecuting attorney consents to the severance, a defendant seeks severance by motion and it is granted, or that one of the defendants is unavailable and does not appear at the hearing. So what we have here today is a defendant seeking severance. As Mr. Frost noted through his attorney, the defendants were charged individually. However, by the pleadings and by the charges and the nature of the charges, all parties have essentially conceded that they are co-defendants, and we have scheduled the cases as such. Mr. Frost is not currently scheduled for a preliminary exam. However, he is charged with conspiracy, and the other 15 defendants are also charged in that same conspiracy, which, as the court and the other defendants who are not present here, and even Mr. Frost concedes, makes them de facto co-defendants. So dealing with the motion for severance in itself, we look to the authority, which is Hannah, and Hannah says that just asking for severance isn't enough, where severance would be appropriate. Where joinder would be appropriate. And there is a threshold that must be met by the defense that was not met in its pleadings.
Brief reply, if I may, Your Honor.
Okay.
So in this particular matter, we take a look at People v. Hannah. Well, in that particular case, you had people that actually were technically and legally co-defendants. In this particular case, we do not have that. And yes, I did state de facto, because certainly that's the way that the Attorney General has taken a look at all 16 of these individuals. However, at the same time, they're not de jure or actually technically co-defendants. And because of that, I don't care what, and for Mr. Frost's sake here, what the other attorneys and what the other defendants wish to do, but he wishes to have, and I believe has an absolute right to, a separate and distinct preliminary examination. My motion more so is more prophylactic than anything, and I'd just be requesting a separate preliminary examination for him.
Oh, thank you.
Thank you.
Again, this is a matter that was charged, as indicated on the record in your argument, in a separate charging document. However, just by the nature of the facts, just as pled and alleged in the felony information sheet, it indicates to the court that this is an incident where your client, Mr. Frost, allegedly acted in concert to commit an act or a series of actions that the State Attorney General's office is charging as felonies. And it agrees, or it states that there was a action or unlawful action for him to agree with several other individuals named, those people specifically named being the other defendants that were individually charged. I think it's appropriate also to remind you that the decision and discretion to both join and sever does rest with the court. We do not have a situation here where the prosecutor is object or granting or seeking to grant a severance. And so I would need to make a determination that there's something individual or so unique about your client's circumstances that would warrant me severancing this matter from the other 15. And then that this would be in the interest of justice and judicial economy. And I don't have that before me. I don't think that this is a situation where his defense largely differs from the defenses that will be set forth from the other parties. I don't know that, but none of that has been brought forth before me today. So all I have now is not guilties on all parties, and they're all being charged with a conspiracy of acting in concert to commit the same series of actions. It's not in the interest of judicial economy to separate his matter or the other 15 defendants' matters so that we can continuously have the same set of evidence brought forth before the court and have a determination made for each individual at a separate date and time. So for those reasons, the court's going to deny your request to sever Mr. Frost's matter from the other 15 cases, and he will proceed on one of the 2 dates for preliminary examination. I don't know if I already set his or if I reserved setting it because of this motion.
I believe you reserved it, Your Honor.
Okay.
That's correct.
And so obviously there is one matter, or one set, I should say, matter of these cases that is going forth next week. I don't think that that would be advantageous for you, but I'll let you advise as to whether or not you could be ready next week to go with that group. There's another set that's going to go in December. Is it the November 2nd? Sorry.
Your Honor.
And then there's at least one who has not been set. And at this point, it's going to be set in either late November, December, or January.
If that's a
Correct.
possibility. And I would
suspected
say.
you would ask for that. That's no problem. I will plan to set this one on that date. Give me a date. Why did I not set the other? There's
The
a
defendant that hasn't been scheduled yet, that has a probable cause conference, is scheduled for that PCC on December 15th at 10 a.m., Your Honor.
Can you make another probable cause conference on that date, and then we can set a date and combine everybody's calendar at that time?
Thank you.
Okay, so that's what we'll do. We'll set this matter for a probable cause conference on December 15th. And albeit I denied your motion, I mean, you're moving forward with just one other individual, so that could be some sort of a concession.
Well, we respect the court's opinion, and certainly we will abide by the court's order.
Any additional matters for the record on this file?
Nothing further, Your Honor, from Mr. Frost.
Nothing from the people, Your Honor. Thank you.
Thank you. You're all set.
Thank you.
I don't see Wanji here.
Yeah, Ms. King.
I don't see her in the breakout room. We have the jail here on a number of cases here. Okay, who's in the jail? Can you hear me in the jail?
I can hear you now.
Okay, well then tell me your name.
My name is Gautama Hatalam.
Okay. Is one. And what's your name, sir? With the dreadlocks?
Jarrell Skates.
Okay, that's Ms. Wanges and then Mr. Nickel. Mr. Nickel was in my waiting room, but I don't know. So, okay, Mr. Nickel, did you need to speak to your client? I don't think he's available.
Yes, Your Honor.
Okay, I'll put you in a private meeting room. Okay, on the record in the matter of the people of the state of Michigan versus Mary Ann Henry, file number 23-02215. Call for appearance.
Good morning, LaDonna Logan on behalf of the people, P69715.
Good morning, Your Honor. May it please this honorable court, George Brown on behalf of Mary Ann Henry, and stands to my right.
Okay, how are you?
Good, Your Honor. How are you?
I'm doing well, thank you. Today was the date and the time that was set for a motion to dismiss. I do have both the motion and the people's response. You can make your argument.
Your Honor, I would ask first, has the court had a chance to review the video?
The court has not reviewed the video.
Would the court allow me to play the video?
Yes, you have the capabilities of doing that.
Thank you, Your Honor.
And the easiest.
People talk a lot.
Well, the easiest way to do that, you probably want to get into my Zoom courtroom and then I'll give you the ability to share it. That way, the Assistant Attorney General has the ability to see it as well. Otherwise, there's a cord that we can hook up to he wants to share a video, Mr. Piccolo. Okay, well, we can't plug in the USB, but let's get him on Zoom. You need to download Zoom or
I've
something.
got some.
Oh,
I just need the password.
sounds good.
Your Honor, I'm in.
Okay, I'm gonna make you co-host. If you wanna mute that, I'll make you co-host and then that'll allow you to share your screen. Just make sure you click share volume when you do that.
Okay. So I can just go back out here.
I'm afraid that if I play with the sound. One second.
No, you keep yours muted. You're gonna share screen and you're gonna click the button on the Zoom that says share sound.
It's kicking me out so that I can just start.
Okay, sounds good.
People talk a lot about, oh, why don't you start?
Your Honor, if I need to step out in the hall to prevent feedback.
No, you muting your device should not affect the Zoom. Did you mute yours? Is that what's
I did,
going
Your
on?
Honor, yeah.
Okay, unmute and see what happens.
The remaining defendants, the worst acting defendants. The problem is,
I'll turn down.
people talk a lot about, oh, why don't you start flipping some of those people so that they can become witnesses against the remaining defendants, the worst acting defendants. The problem is, these are people who have been brainwashed. And when I say brainwashed, how do you flip someone who concedes that they did everything that they're accused of doing, but what they say is, we believe that we were in the right. We think that Donald Trump is the real winner of the election. They legit believe that. They genuinely believe it. So how do you, somebody can't even plead guilty if they wanted to, because they can't admit that what they did violated the law because they still think they're right. Ingham County, where Lansing was located, is a very, very Democratic-leaning county. But I worry that there will be people who just won't care that they clearly violated the law because they believe that the ends justify the means, and that, you know, it's okay to do as long as the end game is getting this autocrat into office, who will surely be the end of democracy in this nation.
Your Honor, we make this motion for dismissal and discharge because there can no longer possibly be a finding of probable cause, no matter what amount of evidence the people provide in preliminary exam. The people have nullified the affidavit upon which they filed this case. Two important issues were not mentioned in the people's response to our motion: specific intent and MRE 801 D2D, an admission by an agent of a party opponent. Now, the defense is not taking any position regarding the facts of this case. We're not required to. The defendant remains presumed innocent, and the burden of proving her guilt beyond a reasonable doubt remains upon the Attorney General. This issue is not about what the defendant said. This is about a genuine question regarding the accuracy of the charging affidavit that has been raised by the prosecutor. The affidavit states that the defendant knew there was no legal reason to create an alternate slate of electors on December 14th, 2020. But on September 18th, 2023, the prosecutor directly contradicted the affidavit by claiming that the defendant was brainwashed, believed that she was in the right, believed Donald Trump won the election. The Attorney General added that the defendant cannot even plead guilty because she still believes that what she did was right. Again, Your Honor, this is not our position. It is the position of the Attorney General regarding the specific intent of the defendant she is prosecuting. Convictions here would require the Attorney General to prove beyond a reasonable doubt that the defendant intended to cheat or deceive. The Attorney General cannot make that assertion now, let alone prove it beyond a reasonable doubt, because what she claims, because she now claims that the defendant believed what she was doing was right. This isn't the position of a layperson. This is not the position of some random attorney or an expert witness. It is the position of the prosecutor. The people claim in their response that the court has no jurisdiction to dismiss. Now, when criminal charges are filed in Michigan, a police officer often performs a swear-to in front of a judge or a magistrate. And when that happens, there's often a little back and forth. Judges and magistrates ask questions of the officer about the facts. There was no such opportunity here because an affidavit was filed instead. The court now knows that the prosecutor disagrees with paragraph 27 of the affidavit, which states that the defendant, quote, knew prior to their meeting on December 14, 2020, there was no legal reason to create an alternate slate of electors. That's important, Your Honor, because paragraph 27 of the affidavit is where the Attorney General alleged specific intent. Now, if the court were to learn during questioning and a swear to that the facts alleged by a police officer were false, it would not be appropriate for the court to authorize felony charges and drag an innocent defendant through a preliminary exam. Are the people claiming that any prosecutor may subject any person to criminal charges and a preliminary exam based on an affidavit, even if the prosecutor asserts that the affidavit is not true? Now, the court knows that the Attorney General's position is that the defendant had no intent to cheat or to deceive. The court has an obligation to inquire about the claims made in the affidavit, acknowledge that the prosecutor claims the specific intent portion of the affidavit is false, and discharge the defendant. The people claim in their response to our motion that the Attorney General's statements are not relevant. They assert that that the statements are mere opinion, and that an attorney's opinion cannot make something more or less probable. They point to a hypothetical of a prosecutor trying to admit evidence that a defense attorney thinks their client is guilty. That hypothetical ignores the fact that the defense attorney is not the one prosecuting the case and is not the one tasked with the burden of proof. It also ignores, Your Honor, the fact that the defense attorney's statements as agents are often admissible against their clients. They point to People v. Smith, in which the Court of Appeals found it had been improper, although not enough to reverse, for the prosecutor to argue that the jury should infer from the prosecutor's charging decisions that the prosecutor had knowledge that the defendant was guilty. But Smith was about protecting defendants from prosecutors unfairly wielding the prestige of their office like a weapon to unduly convince a jury of a defendant's guilt. That case says nothing about a prosecutor stating that a defendant charged with specific intent crimes did not have the necessary intent to commit those crimes. Smith was meant to ensure that the prosecutor didn't have too much power. That is simply not the case here. The people then claim that the Attorney General's statements were opinion, a conclusion that would not assist the fact finder. These statements, Your Honor, were not mere opinion. They were an admission by the agent of a party opponent and therefore admissible under MRE 801D2D, which allows statements that are made by the party's agent or servant concerning a matter within the scope of the agency of employment and made during the existence of that relationship. The Attorney General is the agent of the people of the state of Michigan, a party to this case. Her statement absolutely concerns a matter within the scope of her employment. It was made about this case while she was prosecuting this case at an event that advertised she would be discussing this case as the Michigan Attorney General. The fact that an agent is an attorney has no bearing on whether the statements of an agent come in or not. The people that argue that witnesses cannot offer opinions of guilt. While that may be true for certain witnesses, it is not true about the parties. A defendant may allege that she's innocent, and a prosecutor may allege that the defendant is guilty. A defendant may allege that she is innocent, and as has happened here, a prosecutor may allege that a defendant is innocent. This is about a party making an admission, not about a non-party witness offering an opinion. Now, if the defendant were to have sent a text message to someone claiming that she did have the specific intent to commit these crimes, and if the prosecutor became aware of that text message, would that be admissible? Absolutely. It would be an admission by a party opponent. It would not matter if it were a conclusion of guilt or not. The Attorney General then cites cases dealing with conclusions of expert witnesses like a Michigan Gaming Control Board investigator, medical professionals, or a traffic crash reconstructionist. The statements here were not made by a state gaming investigator. They were made by the party that is prosecuting the case. The people also argue that the defendant has no right to a dismissal based on the Attorney General's statements. They claim in their response that there is no conflict between the affidavit and her September 18th statements. They inaccurately characterize the statements, saying the Attorney General was only speaking about whether the defendants would take responsibility And they compared the Attorney General's statements to a prosecutor casually calling a defendant crazy, saying that that would not concede that they were legally insane. But that's not what she said, Your Honor. The Attorney General claimed the defendants legitimately believed that Donald Trump won the election and that they believed they were in the right. She didn't speculate about the possible probability of them taking responsibility. She said they cannot plead guilty, even if they wanted to, because they still think that they're right. The people also argue in their response that the defendants' beliefs are only minimally relevant. That's simply not true. These are not general intent crimes like battery or drunk driving, where the prosecutor's burden is merely to prove that a person intended to commit an action that led to a criminal act. This case involves allegations of specific intent crimes: conspiracy, forgery, uttering and publishing, and election law forgery. All of these charges require proof beyond a reasonable doubt that the defendant acted with the intention of cheating or deceiving. The defendant's belief regarding whether she is cheating or deceiving anyone is more than just relevant. It's an element of each of the crimes. We now know that the prosecutor's position is the defendant herself did not believe what she was doing was wrong, because according to the Attorney General, the defendant was the one who was deceived. The people also argue that these statements come from a short video clip that lacked nuance, that it did not fully encompass the Attorney General's position on the matter. I cannot possibly think of any conceivable context that would unring the bell, and the people presented none in their response. If the court does still have questions about the prosecutor's position on the issue of the defendant's specific intent, we believe an evidentiary hearing on our motion is appropriate. The Attorney General's statements are not simply the opinion of a random person, some attorney, or a state agency inspector for the Gaming Commission. They are the position of the top law enforcement official of the state. They are the position of the prosecutors who filed these charges. How can a prosecutor file and pursue criminal charges against someone when she herself claims that the defendant did not commit the crimes? The people should not have the right to subject a person to an exam simply because they filed an affidavit with the court. Here, a genuine question has been raised about the accuracy of the affidavit. And yes, a preliminary examination would ordinarily be the proper venue to investigate such a question, if the question was raised by the defendant. But here, the genuine question about the accuracy of the affidavit has been raised by the prosecutor who filed the affidavit with this court to commence this litigation. We are respectfully requesting that the court dismiss the charges against Ms. Henry. In the alternative, we're asking that the court fulfill its obligation to investigate the genuine question of the affidavit's accuracy, a question that was raised by the prosecutor.
Thank you. The Attorney General to respond.
Thank you, Your Honor. First and foremost, I think there is a clear disagreement about what the Attorney General said in her statements, whereas the defendant believes that these statements are directly commenting on an element. The people contend that those statements comment on whether or not a defendant can plead guilty and admit guilt, which is not an element in any of the 8 counts before this court. And as far as a defendant's genuine belief that what they are doing is right, even if they're doing something wrong for the perceived right reasons, still makes that act wrong. And as noted in the people's brief, there is no evidence right now before this court about the sufficiency of mens rea for this defendant or any of the defendants, because we have not had our preliminary exam yet. And when the people make allegations, whether it's in an affidavit, whether it's at the exam, whether it's at trial, those allegations are not evidence. The evidence comes from witness testimony. It comes from the presentation of documents, which again has not happened in this case. So extrajudicial statements made by the Attorney General are not evidence that can be put before this court right now. It is the people's belief that it can't be put before the court, period, based on the case law that we cited, McFarland at 325 Mission Appeal 507, a 2018 case, People v. Fomby at 300 Mission Appeal 46, a 2013 case, which says experts and the top law enforcement officer is could clearly be defined as an expert, cannot give an opinion of the guilt or the guilty state of mind of a defendant. This would never be admissible in court. And first and foremost, as the people said in our response, the court has limited jurisdiction when it comes to a felony complaint. And when it comes to a motion for dismissal, it is properly heard after a presentation of evidence, which we referred to, multiple times, a preliminary examination. We have one scheduled in this matter. It is the people's position that at that point, the defense can properly argue that the evidence is insufficient and not before. The Attorney General's statements do not create a right to dismissal before the court can hear the evidence, which the court has not heard. Thank you, Your Honor.
Any re-argument?
Simply a clarification, Your Honor, as far as what specific intent crimes are. They do differ from general intent crimes. This is not about the outcome being wrong. For specific intent crimes, the intent must be wrong.
Thank you. So we've heard both your argument as well as the responsive argument from the Office of the Attorney General. You've also played a video. I'm still trying to grapple with your understanding as to what rule of law you're relying on to make you playing that video evidence for my consideration in a criminal procedure. It's not even what you played wasn't even, I haven't seen the video in its totality. I can't really ascertain the full context, nor do I believe that that's information that the court can consider as a fact. I mean, this is a statement that was she on the news or was she? I don't even know where she was.
Your Honor, I believe the parties both stipulated to the fact that it was at an event, a political group online, happened on December 18th. Both parties did link a CNN story, which you described where it was.
Okay, and so what is the rule of law that you believe makes this evidence?
Your Honor, this is still a preliminary question at this time. The court's allowed to put away the rules of evidence for a moment and consider all information. This is a statement made by the prosecutor. There's no disagreement about the accuracy of it having happened. It did happen last month.
Okay, she made a statement that there was a concern about whether or not the defendants had been brainwashed.
Your Honor, I would disagree with that characterization. She didn't say that there was a concern. She said that they had been brainwashed. She said that they believed that they were right. They believed that Donald Trump won, and that because of this belief, because they still believe that they're right, that they cannot plead guilty. Those were her statements.
That's talking about a guilty plea. That's not a discussion or determination, about whether or not they can be found guilty, which means that they have to have met the evidence beyond a reasonable doubt to show mens rea, a guilty mind. That is something that needs to be proven along with the actus rea beyond a reasonable doubt. And that doesn't happen on offline or online discussions about what the prosecutor believes may have happened. Because again, I think most of what you played is speculation or maybe what that person making that statement believes, but that's not something the court, I think, can use as a consideration as to whether or not the case can be dismissed. Courts have limited jurisdiction, just as stated by the Office of the Attorney General when it comes to when we can dismiss a matter. And when we dismiss a matter, typically without prejudice, unless the court can find that there's something so grossly egregious or ultra virus that requires a dismissal with prejudice, which can still find its way to the Court of Appeals at this point, because we don't have any binding precedent on that. But as of right now, we have a criminal matter here, again, which charges 8 counts of a felony act or a series of felony actions, which entitle both parties, that being the defendant and the Office of the Attorney General, the prosecutor in this matter, to an evidentiary hearing, which we called a preliminary examination. And at that time is when the prosecutor, the Attorney General's office, has the duty and the responsibility solely upon them to put forth sufficient evidence to establish if there's probable cause enough to move forward with this as a crime, charging your client. with that crime. And so this is not a time for the court to make a determination as to whether or not we would have enough evidence to support a guilty mind, that being mens rea. This is not a time for the court to make a determination as to whether or not there was any actions that was taken by your client in furtherance of a guilty act. So for those reasons, because I think it's preliminary and it's something that probably should be best suited or be brought over at the circuit court level, the court is going to deny your motion. This matter will continue to preliminary examination for the purposes of establishing probable cause.
Thank you, Your Honor.
Thank you. Any additional matters for today's?
Not for the.
Okay, and this matter is
None for the
scheduled for
people, thank
preliminary
you.
examination on October 12th,
Yes, ma'am.
correct?
Yes.
Okay, any additional matters from you, Ms. Logan?
No, Your Honor, thank you.
You're all set. I don't see Mr. Etheridge.
I have seen Mr. Etheridge. He is around, Your
He's,
Honor.
I saw him, he was talking to his client.
Okay,
Okay,
thank you.
he is here in the building. He's around. I've given him the plea sheet for his client. So-
Mr. Green, which matter are you here for?
Good morning, Your Honor. Thomas James Nett.
Okay, we're waiting for the the public defender to return on that matter. Ms. Donnelly, you're here on King.
Yes, Your Honor.
On the record in the matter, the people of the state of Michigan versus Diamond Catrice King, file number 23-02869, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
An assistant public defender, Sarah Donnelly, on behalf of the defendant, Diamond King, who is present and standing to my right.
Okay, Ms. King, today is the date and the time that's set for preliminary examination. How are you?
Good, how are you?
I'm doing well, thank you. Let's see, my understanding is that there's going to be a request for a waiver of the timeline. Is that accurate?
That is my understanding, Your Honor.
Yes, Your Honor.
And who's making the request and for what reason?
I am, Your Honor, just to give Ms. King more time to discuss the options that we've been presented by the prosecutor.
Was there an offer?
Not as such, Your Honor.
Okay. And have you received the discovery?
I have.
Okay. So, Ms. King, you understand that you have the right to have a preliminary examination in this matter?
Yes.
You understand that you have the right to have it within 21 days of the date of your arraignment?
Yes, ma'am.
You were arraigned on this matter back on September 18th. And you're scheduled to have your exam today. Are you willing to waive that timeline so that you can have this matter reset, giving you more time to work with your attorney to formulate a defense?
Yes, ma'am.
Okay, anybody threatening you to get you to waive the timeline?
No, ma'am.
Any promises being made to you in exchange for that waiver of the timeline? Yep.
Yes, ma'am.
Who's making a promise to you?
Yes, she asked.
Who promised you something if you waive the
Oh,
timeline?
no, ma'am.
Oh, no one? Okay, very good. Okay, I'll find that you're giving your waiver of the timeline freely and voluntarily. I'll reset this matter.
First and 9:30.
December 1st at 9:30. Do you have any questions today?
No, ma'am.
Okay, any other matters that we need to address today?
Nothing from the people, Your Honor.
None for defense, thank you.
The bond set at 200, personal recognizances will continue. We'll get you a copy of your notice to appear, okay?
Thank you.
You're welcome. I don't know, Mr. Nicholas. Oh, here he is. Thought you were on Zoom. Okay. On the record in the matter, the people of the state of Michigan versus Guatama Haptalem, file number 22-02769 FY, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Assistant Public Defender Scott Nick on behalf of Mr. Houghton.
Okay, and Ms. Haptalem, you can hear me?
And Your Honor.
Okay, today was the date and the time that was set for a preliminary, I'm sorry, except for a plea. I do have a plea sheet here. It says the people are offering for the defendant to plead guilty to an added count 4 of controlled substance use of methamphetamine under MCL 333.74042A-A, and an added count 5 of attempted police officer assaulting, resisting, obstructing. In exchange, the people will dismiss counts 1, 2, and 3. Is that a complete and accurate understanding of the plea offer to your client?
Yes, Your Honor.
Okay, Mr. Hapsalon, did you want to accept that offer today, or did you want to deny it and continue to your preliminary examination?
I will be accepting that offer, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? God bless you.
I do.
Thank you. You can put your hand down. Okay. In order for you to accept this offer and plead guilty to these amended charges, you would have to first understand your rights and then give those rights up. Those rights include the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Okay.
And you have the right to require the prosecution to prove your guilt at a jury trial. You have the right to jury trial. You have the right to confront, cross-examine, or question any other witnesses that the prosecution intends to call against you at that trial. You have the right to call your own witnesses to testify on your behalf at trial or present evidence at trial that you believe further a defense to the charges being brought against you. You have the right to remain silent at your trial and not have silence be used to prove or imply that you're guilty. You understand each of those rights?
Yes, Your Honor.
Are you willing to give those rights up today in order to plead guilty to use of a controlled substance and attempted police officer assaulting, resisting, obstructing?
I am.
Is anybody making any threats to you to get you to waive your rights and plead guilty?
No, Your Honor.
Any promises being made to you in exchange for you waiving your rights and pleading guilty?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
You understand a guilty plea could result in a conviction that you may need to report to either your current employer or you may need to report this conviction to a future employer.
Yes, Your Honor.
You also need to understand that a guilty plea could result in a conviction that may have impact on travel or immigration status that you may be seeking. Do you understand that?
Yes, Your Honor.
Okay, and with that understanding, you still wish to give up your rights and plead guilty?
Yes, Your Honor.
As to the added count 4 of controlled substance use of methamphetamine, how do you plead?
Guilty, Your Honor.
As to the added count 5 of attempted police officer assaulting, resisting, and obstructing, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Correct.
Factual basis, please.
Yes, Mr. Hotel, back on May 2nd, 2022, were you at a Quality Dairy located at 700 North Pine in the city of Lansing, Ingham County?
I was.
And did you did you come into contact with law enforcement?
I did.
Specifically a uniformed Lansing Police Department officer?
Yes,
And you provided him with your name, correct?
I did.
And did he run your name through their system to determine if you had warrants?
Yes, he did.
And did he determine that you had a warrant for your arrest at that time?
Yes, he did.
And did he attempt to place you under arrest on that warrant?
Yes, he did.
Did you hear the question?
No, it blanked out for a second.
Okay. When he tried to place you under arrest, did you try to run away from him to stop him from arresting you?
Yes.
Okay. But he was able to take you into custody?
Yes.
And on it, when he took you into custody on that date, were you in possession of methamphetamines?
I was.
I believe that's a sufficient factual basis.
Mr. Brodowitz, any questions?
Nothing from the people, Your Honor.
The court satisfied with the factual basis. I'll accept your plea, find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing December 1st, 2023 at 8:30 in the morning. Prior to sentencing, you need to undergo a pre-sentence investigation as well as a substance abuse assessment. He's being held on this or something else.
He is being held on this to ensure he is present for the plea hearing.
Okay, sounds good. So we will make sure that you undergo a substance abuse assessment and get your PSI taken care of while you're in the custody of Ingham County Jail.
Actually, Your Honor, I would like to request that the court consider releasing him on a personal recognizance bond. He did miss his plea hearing last year following his release from the Clinton County Jail. However, since then, he does have an address in East Lansing that he resides at. I was able to get a new phone number from him. And so I believe the court will be able to get notices to him, and he is living in this area now. So he should have no trouble traveling to the courthouse to appear at his hearings and to make sure that he gets his assessment and the PSI done.
December 6, 2022, defendant failed to appear. I held it 48 hours to give him a chance to appear. He didn't. December, I think this says 26, 2022. I could be reading that incorrectly because it's faint, but defendant again failed to appear. It must be December 20th. Failed to appear. Another bench warrant was issued. January 20th, defendant failed to appear. Motion is denied.
Understood, Your Honor.
Okay, so we'll get you all set up for your sentencing while we have you in custody. Any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing from defense, Your Honor. Thank you.
Thank you. You're all set, Mr. Haftalem.
Thank you.
I thought I see Ms. Wanji. Did she go in the breakout? Okay. See Mr. Neal? No,
It may be on Zoom. No.
he's not. I see Mr. Crino. Did we see Mr. Etheridge? No. Ms. Wanji's on Zimmerman. Are we running that?
I do not believe witness has appeared on that one, Your
Ms.
Honor.
Wanji's on a lot. Let's see here. She's got all my docket today. She's on Zoom. She's on Zoom. And then we need Mr. Etheridge for
Yep, let me go see.
that matter, or two matters.
the issues with the paying and see if they have anybody that can assist you.
Players will meet in the cafeteria. Parents pick their players at 3:30. So it's Friday. And here.
Hello?
Yes. Ms. Wanjai? What's going on?
I will say I will update it.
They don't know what's going on right now. situation, both of it going on.
$54A, 7.
Barely, I could barely speak to my attorney, like what is going on? It's just getting
Mr. Etheridge.
Yes, Your Honor.
You're here on the matter with Net.
Yes, Your Honor.
Okay, on the record, in the matter of the people of the state of Michigan versus Thomas Net, file number 19-03689, counsel appearance.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Attorney Derek Fish is also public defender on behalf of Mr. Net. Mr. Net is appearing by Zoom.
Okay, today was the date that we reset this matter for a new PCC. I granted his bond last week so that he can return home and appear virtually, and the parties had worked out an agreement whereby he would bring his arrears down. How are we proceeding at this time?
This time he will be waiving the preliminary examination, have the matter go to circuit court to exercise the plea offer that has been presented.
And Mr. Green, are the people waiving their right to exam as well?
Yes, Your Honor.
Okay, Mr. Net, can you unmute, please?
Yes, Your Honor.
Okay, Mr. Net, do you understand that you have the right to have a preliminary examination in this matter here in the district court?
Yes, Your Honor.
Okay, you understand that the purpose of the examination is to require the prosecution, which is the Office of the Attorney General, to meet their burden of probable cause. So they need to establish that they have probable cause sufficient that a crime was committed, and then sufficient probable cause to charge you with those crimes. You understand that?
Yes, Your Honor.
Are you willing to unconditionally waive your right to exam today?
Yes, Your Honor.
Anybody threatening you to get you to waive your examination?
No, Your Honor.
Any promises being made to you if you waive your examination?
No, Your Honor.
So you're waiving it freely and voluntarily?
Yes, Your Honor.
Okay. So you understand that once you waive it, this matter will be bound over and there won't be a hearing on probable cause in this court. And you can't change your mind once you get to circuit court and decide that you want to have your exam. You understand that?
Yes, Your Honor.
Okay. Bind over on this matter is going to be October 18th. You do not need to appear in the circuit court on October 18th. That's the date that they're going to get the file from this court. Okay, Mr. Net?
Okay, Your Honor. Thank you.
Your next court date will be in circuit court, but it'll be a pre-trial. Mr. Etheridge will be made aware of that date. Mr. Etheridge, can I get you to sign this, please?
Yes, Your Honor.
Do you have any questions today?
Oh, are you talking to me, Your Honor?
That's correct.
Okay. Yes, Your Honor. There is a hold on my driver's license. Is there a way I can get that hold off so I can work more, so I can get these back child support paid up as soon as possible?
Your Honor, I've advised him and I've talked to the Attorney General today. There's nothing the Attorney General can do. He has to go through front of the court. That judge has placed that order on there. And I've advised him he needs to get an attorney or go through that court. The criminal case we have doesn't have anything to do with this driver's license suspension.
That's correct. I don't have any control or interest in the hold on your driver's license. You need to do that over at the family court through the front of court office, okay?
All right. Thank you, Your Honor.
You're welcome. Bond in this matter was $3,390 cash, which was to be applied to the overall arrears, correct?
Correct, Your Honor.
Okay, and that will continue. Any additional matters for today's record?
No, Your Honor.
No, Your Honor. Thank you.
Thank you. You're all set, Mr. Net.
All right. Thank you, Your Honor.
Thank you, Judge. Have a good morning.
Same to you. Let's see, Kayla Walker's who? Oh, okay, I just need to sign. Okay. On the record in the matter of the people, the state of Michigan versus Mary Jean Harris. Is she here? Yes. File number 19-03855, council appearance.
Jeff Rado, on behalf of the people, Your Honor.
Good morning, Your Honor. Everyone from the public defender office for Ms. Harris.
Okay, how are you, Ms. Harris?
Hi, how are you?
I'm doing well. Today's the date and the time that was set for a preliminary examination. I do have a petition here from the defense requesting forensic evaluation. I do recall during the probable cause conference last week, I think it was Ms. Harris's son that expressed some concerns, and you met with her privately, and you are requesting to have her evaluated. Is that correct?
It is correct, Your Honor.
Okay. And was the prosecution seeking to object to that?
No, Your Honor, the people would not be objecting to that.
Okay, based on the petition, which indicates a history or a prior history of some mental health concerns, as well as concerns expressed to the court from the defendant's son, the court will grant your request and order the defendant to undergo an evaluation as to competency at the Center for Forensic Psychiatry. Also grant the request for order for evaluation relative to criminal responsibility. We will adjourn any other proceedings pending the results of those evaluations. So the court will find a good cause to adjourn the preliminary examination proceedings. Any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing for the defense, Your Honor. Thank you.
Thank you. You're all set for today on that matter. And now Zimmerman was released already, correct?
Yes.
On the record in the matter of the people of the state of Michigan versus Jerron Summers, file number 23-02864, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. May I need to want you from the public defender office of Mr. who's present in the courtroom.
Okay, how are you, Mr. Summers?
All right, so.
I'm doing well, thank you. Today is the date and the time that was set for a preliminary examination. Are we continuing to exam today?
At this time, Your Honor, I believe the defense will be requesting an adjournment and the people would not object. My understanding, the defense would like to seek some additional discovery in this matter.
That's correct, Your Honor. We believe that the 911 tapes are necessary for this matter.
Okay.
That's an adjournment.
Okay, and have you discussed with your client his right to have his exam within 21 days?
Yes, Your Honor, we have it.
So you understand that you have the right to have a preliminary examination within 21 days of your arraignment?
Yes, Your Honor.
Okay, and are you willing to waive that right in order for us to reset this beyond 21 days?
Yes, Your Honor.
Anybody threatening you to get you to waive that right?
No.
Was there promises made to you if you waive the timeline?
No.
Okay.
December 7th at 8:30.
December 7th at 8:30. Get your copy of your notice to appear. Your bond was set at. Two different handwritings in here. 300 cash surety that will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for the defense, Your Honor. Thank you.
Thank you. You're all set. Shakir Jameson. Do I have that file? It's not on my- Oh, Rogers Jameson is on my phone. Okay. The person just left. Okay. On the record in the matter of the people of the state of Michigan versus Jarrell Skates, file number 23-02908, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. Good morning, Your Honor. I need to want you from Mr. Skates, who's appearing by Zoom from the county jail.
You can hear me, Mr. Skates?
Yes, Your Honor.
Okay. Today's the date and the time that was set for a plea. I have a plea sheet here. Mr. Skates, it states that the people are offering for you to plead guilty to an added count 2 of reckless driving under MCL 257.626, and they'll dismiss count 1. Is that a complete and accurate understanding of what you were offered?
Yes, Your Honor.
Did you want to accept that plea today?
Yes, Your Honor.
Please raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can put your hand down. Okay, Mr. Skates, reckless driving is a misdemeanor. It's punishable with a maximum penalty of 90 days in jail and/or $500 in fines. You have the right to have a trial in this matter, and you have a right to jury trial. At the time of your jury trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You understand that?
Yes, Your Honor.
You have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt at a trial. Do you understand that?
Yes, Your Honor.
You have the right to have a trial by jury. Do you understand that?
Yes, Your Honor.
Okay, so at the time of your jury trial, you have the right to remain silent and not have silence be used against you. You have the right to see, hear, or question in court any of the witnesses that the prosecution intends to call against you. And you also have the right to call your own witnesses or present evidence that you believe further a defense to the charge being brought against you. Do you wish to give up each of those rights today?
Yes, Your Honor.
Anybody threatening you to get you to give up those rights?
Oh, Your Honor.
Any promises being made to you in exchange for a guilty plea?
No, Your Honor.
Are you currently on probation or on parole?
I believe I had a violation of probation.
So you are on probation before which court?
It was for a domestic violence. It was for a failed drop, I believe it was.
When did you get placed on probation?
This was back, it was like 2 years ago. It was like a 12-month probation. It was for the domestic
Oh, okay,
violence.
because I think at the time you were arraigned, you denied that you were on probation. So you recall being on probation now?
I really can't really remember, Your Honor.
Okay, looks like you are on probation before Judge Flores.
Yes, Flores, Your Honor.
Okay. You understand that a guilty plea could potentially result in a violation of your probation status?
Yes, Your Honor.
Okay, and you also understand that a guilty plea could result in a conviction that may have impact on travel or maybe immigration status that you may be seeking?
Yes, Your Honor.
Okay. As to the added count 2 of reckless driving, do you plead guilty, not guilty, or stand mute?
Guilty, Your Honor.
Are you pleading guilty because you believe you're guilty?
Yes, I am guilty, Your Honor.
Okay, actual basis, please.
Mr. State, on September 19, 2023, were you in the city of Lansing? Can you hear me?
I didn't hear the question.
On September 19, 2023, were you driving your car in the city of Lansing?
Yes, I was.
And it was at the corner of Miller and Coulson, correct?
Yes, Your Honor.
And you were driving you were driving the car in a negligent way, in a way that was with disregard for the safety of the public. Is that correct?
That is correct, yes.
Thank you.
Any questions for Mr. Brodowitz?
Nothing from the people, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. My records reflect that you were originally arraigned on this on September 20th. And you had a bond of $3,500 cash surety. I amended your bond at our last court date, September 29th. to PR, so you have at least 10 days custody. I'll give you credit time, sir. You're all set. Thank you. You're welcome. That was it. Is this Joyce Martin?
Yes, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Joyce Martin, file number 19-04357, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Morning, Your Honor. Attorney Derek Etheridge from the Office of the Public Defender on behalf of Ms. Martin, and Ms. Martin is standing to my right.
How are you, Ms. Martin? I'm doing well, thank you. You can remain standing.
Okay.
Today's the date and the time that's set for a preliminary examination. My understanding, Ms. Martin, is that there was an offer that was extended to you. It's for you to plead guilty to an added count 2 of use of a controlled substance, that being a narcotic, cocaine, or ecstasy, and that the people would dismiss count 1. And there's a Killebrew of no upfront jail. Killebrew means a sentencing agreement that I won't sentence you to upfront jail. And the people are not objecting to 7411 status. Is that a complete and accurate understanding, Mr. Etheridge, of the offer?
Yes, Your Honor.
And ma'am, did you want to accept that offer today?
Yes.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, sir.
You can put your hand down. I have an advice of rights and pre-information sheet. It has today's date on it. There's a signature affixed to the bottom. Is that your signature?
Yes, sir.
Did you read this document? Did you read it?
Yes.
Okay, you understand the rights that are listed here?
Yes.
Do you have any questions about any of these rights?
No.
Are you willing to give up all of these rights today to accept the offer?
Yes.
So you understand that you would be giving up your right to the presumption of innocence. So that means you're innocent until proven guilty.
Yes.
You want to give up that right?
Yes, sir.
Okay. And you understand that you have the right to have a jury trial, and you have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt at a jury trial. Okay, you also have the right to remain silent at your trial and not have the silence be used against you. You have the right to see, hear, or question any witness in court that the prosecution intends to call. You also have the right to call your own witnesses or present evidence that you believe further defense to the charge being brought against you. You want to give up those rights as well? Anybody making any threats to you to get you to waive your rights today?
No.
Has there been any promises made to you to induce you to want to waive your rights and plead guilty?
No.
Are you currently on probation or on parole?
No.
You understand that a guilty plea could result in a conviction that you may need to report to either your current employer or a future employer. You may have to report a conviction. If you plead guilty, you may have to report this conviction to your job. You understand that?
Yes.
Okay. You also could have a conviction by pleading guilty that would impact or hinder your ability to travel to certain places, or could affect any immigration status that you may be seeking. Do you understand that?
Yes.
Okay. And you still want to give up those rights?
Yes, Your Honor.
There's a sentencing agreement. That's the Killebrew that I discussed, that you will not be sentenced to upfront jail. I'm not a party to that agreement. That's an agreement between you, Mr. Etheridge, and Mr. Brodowitz, okay? If at the time of your sentencing, I determine I'm going to sentence you to jail, I would advise you of that. And then I'll also give you the right to withdraw your plea at that time, okay? And then lastly, are you pleading guilty or entering a guilty plea to the added count because you believe you're guilty? Are you pleading guilty, or you're seeking to plead guilty to the added count of controlled substance use because you believe you're guilty of that?
Yes.
Okay, as to added count 2, controlled substance use of narcotic, cocaine, or ecstasy, do you plead guilty, not guilty, or stand mute? Can you speak up so I can hear you? Factual basis.
Thank you, Your Honor. Ms. Martin, I'm gonna draw your attention to June 7th of 2019. At that time, you were located at 102 West Michigan Avenue, 3rd floor, City of Lansing, Ingham County, State of Michigan, correct?
Yes.
At that time, you had been arrested for a separate warrant or incident, and you were being processed into the jail or the city lockup, correct?
Yes.
And as part of that and processing into lockup, you were searched, correct?
Yes.
And when you were searched, you were found to have two small bundles or two small packages of cocaine, correct? And you knew you had cocaine and you didn't have a prescription to have it, correct? And you had that cocaine because at that time you were using cocaine, correct? Thank you.
Any questions from the prosecution?
People are satisfied with the factual basis here.
Okay, the court is also satisfied with the factual basis. I will accept your plea. I find your plea to be made freely, voluntarily, and intelligently. Matter is set for sentencing December 1st, 2023 at 8:30 in the morning. We're giving you a notice to appear now. You need to go downstairs to the 5th floor immediately upon leaving my courtroom so that you can check in with the probation department. They will get you set up for a pre-sentence interview. You're going to need to be screened for substance abuse, and then they'll provide me with a recommendation as to how you should be sentenced, as well as if you're eligible to be placed on 7411 status, okay? Do you have any questions at this time?
No, does this probation department have the ability to send her to a place with a sliding scale or that waives fees? She is concerned about some of the costs that she has very limited or no income.
They can try to connect her with some of those resources so that she can avoid those costs. I think usually Crystal Ray or even CMH, if she has the ability to connect with them, could do one as well, okay?
Thank you, Your Honor. So when you go down there, make sure you tell them what we're talking about. Try to give you assistance we want to pay as much. Okay? Thank you, Your Honor.
No problem. Any additional matters for the record?
Nothing from the people, Your Honor.
Not from the defense, Your Honor. Thank you.
Thank you. You're all set. Okay, on the record, in the matter of the people of the state of Michigan versus DePriest Morel, file number is 23-02444. FY, counsel appearance.
Your Honor, thank you and good morning. Assistant Prosecutor Bill Crino on behalf of the people of the state of Michigan.
Good morning, Your Honor. Rico Neal appearing on behalf of DePriest Morel, who is present via the video system from the Ingham County Jail.
Okay, today was the date that was set for a motion hearing. This was a motion, I believe, that was filed by the or requested by the defense. Is this motion for to address the bond, correct?
That's correct and accurate, Your Honor.
Okay, and I remember a little over a month ago, there was a request for a bond to be set, and I denied that motion pending pretrial service investigation report. I don't see where I have received one at this time, and I think that we did follow up. Did we receive one? Yeah. There's not one in the file. Last thing in the file is date to appear on September 20th.
Your Honor, I did receive a copy. I don't know if Mr. Crino received a copy, but I received a copy from.
Apparently the court did too, that just wasn't provided to me.
Okay.
I did receive a copy, Your Honor. Thank you.
Okay, and so I do have a copy of this a trial release assessment, risk assessment, which ultimately concludes that a deviation to release on own recognizance not recommended due to the circumstances and information provided in the body of that report. And so, Mr. Neal, did you want to further address that?
Thank you, Your Honor. I did have an opportunity to review that report as well, understanding given the nature and the severity of these charges that personal recognizance bond is not recommended. I am asking this court to set a bond that my client that is reasonable in which he could potentially post in the future. This is a 17-year-old young man with no prior history, no prior failures to appear, would appear at all future court appearances. If released, he would be returning back home to reside with his mother. As such, Your Honor, don't believe he's a flight risk. I understand the court may have some concerns regarding the safety for the public, but I believe the facts shown that after the hearing will shed some light in this particular matter, which would demonstrate that my client is not a danger to the public as a whole. As such, I'm asking this court to set a reasonable bond in which he could potentially post. Again, he would appear at all future court appearances and also resume his education at Okemos High School. We're not opposed if the court is inclined to impose the use of a GPS tether as well.
Mr. Crino, you can respond.
Your Honor, thank you. The defendant is charged in a 2-count complaint with open murder and felony firearm. He is charged in connection with the shooting homicide of 21-year-old D'Angelo Hayward on August 3rd of 2023. Your Honor, my understanding, and I'm filling in for APA Sarah Polda here today, but my understanding is that pursuant to MCR 6.106B, the defendant is currently being held in the Ingham County Jail without bond. Under Section 3, a hearing to determine bond must be set within 90 days. The defendant was arraigned on August 4th, which means a bond hearing to set a bond for this defendant must be done by approximately November 4th. And I believe we are pending preliminary examination on November 16th of 2023. So as such, we agree with the defense that the defendant is entitled to a bond hearing today and that the defendant is entitled to setting of some kind of bond. It sounds like the defense is not asking for a personal recognizance bond in accordance with the presumption. We, of course, would be strongly opposing a request for a personal recognizance bond. It does not address the legitimate concerns of bond to include the protection of the community and to assure this defendant's reappearance. You know, we are aware of the pretrial services recommendation in this case, Your Honor. One of the things that the pretrial services recommendation report does not adequately address is bond factor E under MCR 6.106, and that's the seriousness of the offense charged, the probability of conviction, and likely sentence. Your Honor, in a case that is as serious as this, the severity of this offense must be something that is highly weighted in determining the form, nature, and amount of bond. What we expect you will hear in this case, Your Honor, is that this was an extremely serious, intentional, and lethal assault that not only resulted in the death of a 21-year-old victim, the shooting of another young girl, but it also created an extreme risk of death or harm to this community. And you haven't heard the proofs, you haven't heard preliminary examination, but what we expect you will hear is as follows, Your Honor. At the time of this incident, this young defendant was armed with a fully loaded 9mm semi-automatic handgun. We expect you're going to hear about 2 separate confrontations that occurred, one inside the defendant's residence and one that occurred immediately outside his residence in a common apartment complex. During that second confrontation that occurred just outside the defendant's apartment, we expect you're going to hear that this victim and his 16-year-old sister were more than a building away and were either walking away or running away from this confrontation. You will hear that this defendant aimed and pointed his loaded 9mm handgun and intentionally fired 6 rounds across that public parking lot, striking the victim twice, including fatally in the back and his sister in the arms. The victims then got into a vehicle and started to drive away. The victim, as he was driving, collapsed and there was an automobile accident. So utter chaos in our city as a result of the conduct of this defendant. You're going to hear, Your Honor, that this happened at 4 o'clock in the afternoon in a public apartment complex. So not only is the defendant fatally shooting a 21-year-old victim and his sister, but he is discharging 6 rounds across a public parking lot. And this is extremely serious conduct, and this is creating an extreme risk of harm, not only to the victims, but to our community at large. So this is certainly not the type of case that a personal recognizance bond under the presumption would be required. And it's our position that it must be addressed with a high monetary bond to ensure the protection of the community. Your Honor, we are not persuaded by the fact that this defendant is young or that he will be released into the custody of his mother. This incident happened while he was living with his grandmother. It happened outside his own residence. He was armed with his 9mm loaded handgun. A search warrant was subsequently done at that apartment. And inside the apartment was found a second semi-automatic weapon with a loaded extended clip that we can only infer was this defendant's or someone that was associating with the defendant that day. Lastly, Your Honor, the defendant's charged with open murder, which includes charges of first and second degree murder. It would be the people's intention in this case to pursue charges under an open murder theory under first and second degree murder. And if the defendant's convicted, Your Honor, that would include a likely lengthy prison incarceration in the Michigan Department of Corrections. And when we look at the severity of the penalty or possibility of penalty, that creates an inherent flight risk. Our position, Your Honor, in this case is that monetary bond should be set in this case in the amount of $250,000 cash. If the defendant is released, the people would ask for GPS tether, a strict curfew, standard conditions, including no possession of weapons and no contact with the surviving victim, who is Ariana Russell. Thank you, Your Honor.
Thank you. I'm interested only because has been mentioned multiple times that Mr. Rico Neal, you wanted to have your client released so that he can attend school. Has he been attending school prior to the alleged incident?
It's my understanding, Your Honor, he was attending Okemos High School either in person or virtually online, which he would resume if released.
Okay. And the Okemos public school district has not restricted his ability to attend school pending this action or this litigation?
Not to my knowledge as of today, Your Honor.
Okay. I reviewed the report again as it relates to the risk factors, and I've heard the argument of the prosecution as to factor B, which is the severity of the offense. And as charged, again, this is a offense that's punishable by life in count 1 if convicted. And it's homicide, open murder, a statutory short form. I do see that the allegations are crimes charged against or of violence against another person with the use allegedly of a firearm to commit those actions, and that in considering that the defendant did not have any prior convictions noted on his history and the age of the defendant, I think that he would benefit from being able to go to school if he's able to do so, and if he has been doing so. I don't think that personal recognizance bond is appropriate. I will grant the request to set a bond. It will be set in the amount of $150,000 cash with GPS tether. The defendant is going to be ordered to be on house arrest, and he's only allowed to leave for the purposes of going to school. The address that we have on file as his address, is that the address on Meridian Club Drive?
Your Honor, I did notice that there was a different address that that was provided to me by his mother in the bond report, which is different than that which was provided to me by his mother. The address listed in the bond report was an Okemos address, I believe.
Right. Yeah, my understanding is that the defendant was residing with his grandmother.
Yes, he was residing with his grandmother, but he would be residing with his mother if released. And the address is 2120 Clinton Street, Okemos, Michigan.
So I'll note here that he'll reside at the address of 2120 Clinton Street in Okemos. While on bond, he's not to use, purchase, or possess a firearm, ammunition, or other dangerous weapon. He's not to travel outside the state without prior approval of the court. You're not to engage in any assaultive or threatening behavior. He's not to use, purchase, or possess drugs or alcohol without a valid prescription. He needs to report to pretrial services within 48 hours of release. And again, he needs to attend school. I'm not setting a curfew at this time because he's not allowed to leave. He's under house arrest unless going to school. What are the hours of his school?
Your Honor, Okemos, I believe Okemos starts, I used to teach out there. They start at 7, I want to say 7:40, and they get out around 3 o'clock.
And that's the address of 2800 Jolly Road. So he will be allowed to be at the area of 2800 Jolly Road during the hours of school, so long as he's participating in school. He'll be expected to be back at the address of 2120 Clinton Street no later than 3:30. Should be after school is out. Do you have any questions about your bond conditions? Mr. Morrell?
No, ma'am.
Any additional matters for the record today, council?
Your Honor, thank you. I did not hear you, and I apologize, when you set the monetary bond amount. So my understanding is you set the monetary bond at $150,000 cash, and then upon release, if that's posted upon release, the conditions that we just discussed. Is that accurate?
That's correct, with GPS tether.
Great. Thank you very much, Your Honor.
Thank you. Any additional
Nothing.
matters, Mr. Nick?
Nothing further, Your
Thank
Honor.
you.
Thank you very much.
Thank you, Your Honor.
You're all set for today.
Thank you.
Mr. Skates, were you waiting for something?
Yeah, I was wanting to request a PR bond to see if I can go back to work and pay my fines.
PR bond on what? I gave you time served on the matter that I just had, so you're done.
Oh, okay. But sorry about that. Thank you, Your Honor.
No problem. Okay, and we have whom here? Jameson Rogers. Okay, are we having an exam?
No, you're not.
Okay. On the record, in the matter of the people of the state of Michigan versus Shakir Rogers Jameson and file number 23-02850. Appearance, please.
Jeff Rodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. Good morning, Your Honor. Manager 124, Mr. Jameson Rogers.
What makes you think I want to see your belly?
I'm sorry, I'm hurting. I was gonna apologize to you beforehand before we started, but Shakir Rogers Jameson.
You're in some pain?
I'm in a lot of pain. It's scary.
Okay, you can have a seat. Okay, today was the date and the time that was set for a preliminary examination, and we're not continuing today, is that correct?
That's correct, Your Honor. I had some discussions with Ms. Wanji beforehand. Apparently, Mr. Jameson Rogers was in the hospital. I will let Ms. Wanji speak more on that, Your Honor.
Yes, Your Honor. My client was at the emergency room, and his mother did call me, and I was under the impression that he wasn't going to show up, but he came and he's on a lot of pain. And I talked to the hospital, we asked him to go back to the hospital, but he was scared that if he goes back to the court may issue a bench warrant.
Okay. You're in some pain. We want you to go get that addressed. We can reset this. I'll find good cause to go beyond the 21 days, okay? Okay, you should head out to the hospital. We'll get you a new date. You have an ambulance coming to get you?
I said I think I might, so I'm gonna be able to probably make it on my own.
Okay. December 7th, at what time? 9. At 9 a.m. If that's what you intend to do, you can go to the lobby and call an ambulance, okay? Or you can step out and call the ambulance. They can come get you up here, okay?
I would need somebody's phone.
Thank you. We'll get the notice to his attorney. You can go, you can step out.
No, I'm gonna contact him, call 911. Thank you.
Thank you.